The Supreme Court here is the final stop for Theresa May's government in what has been a long rearguard action to prevent Parliament ruling on when the Brexit negotiations should formally begin. May's argued her government should have the last say using ancient powers of royal prerogative. That prerogative gives the Prime Minister and the government the authority to make decisions without consulting Parliament, similar to the executive order in the United States that permits the US President to bypass Congress. The case against May was brought by financial businesswoman Gina Miller, who said the whole point of Brexit was to bring back powers from Brussels and give them to the UK Parliament. That narrative has received a sympathetic ear from judges. The UK government has now then on standby plans to rush through Parliament legislation which will begin the process. That's a tight schedule though for Prime Minister May, who promised to start the negotiations in March at the latest. And while members of Parliament are unlikely to directly challenge the outcome of the Brexit referendum, the wording of the government legislation needs to ensure against the tabling of lengthy amendments, dragging out the process. And that's a tough call, as the wording must incorporate not just something for members of Parliament who oppose Brexit, but for the other parliaments in the United Kingdom, Scotland, Wales and Northern Ireland. It's why observers here describe this ruling as the most politically significant in decades. Richard Bestic, CGTN, the Supreme Court, London.